Hello, everyone. Welcome to the SIAC and NYU Law webinar on CISG in International Arbitration. I am Piyush Prasad, Associate Counsel at SIAC, and I will be the moderator today. Trade in a globalized world underscores the importance of the United Nations Convention on Contracts for International Sale of Goods, in short, CISG. The contract of sale is the backbone of international trade, and CISG is a legal model for harmonizing contract law. It aims to provide a modern, uniform, and fair regime for contracts for international sale of goods. As of today, CISG has been adopted by 93 states, including USA, China, France, Germany, and Singapore. Significantly, these states represent over 2/3 of the global economy. Thus, subject to parties' choice, CISG potentially applies to more than 3/4 of the world trade. Keeping statistics aside and putting things simply, Apple's iPhone is designed in the USA, manufactured in China, and sold across the world. Many aspects of what I just described fall under the purview of CISG. Disputes in the international trade are not uncommon. In fact, last year, 21% of the disputes in SIAC arbitrations related to trade, the second highest after corporate disputes. We have also seen a number of applications for emergency arbitrator being filed in trade-related disputes. CISG was approved and open for ratification in 1980. So 2020 marks its 40th anniversary. On this occasion, today, we will take stock of the impact of a CISG on international arbitration. We will commence the discussion by dealing with the threshold issues, that is, CISG as the applicable law of the contract, the issues arising under CISG, and finish with how courts have dealt with CISG issues in applications to set aside awards. The panelists comprise three of the leading experts on CISG in the world, whom I will now introduce in order of their presentation today. First, we have Dr. Frederick Rosenfeld, who is a partner at Henfeld in Hamburg. Hello, Dr. Rosenfeld.
Hello, Piyush.
He regularly acts as counsel as well as arbitrator in international arbitration proceedings. In spring this year, Dr. Rosenfeld was invited to teach arbitration as global professor from practice at NYU School of Law. Today, he will deal with the topic, the law applicable to the merits in arbitration, which is based on a paper which co-authored with Professor Franco Ferrari, which will be published in the Cambridge Compendium on Arbitration. We also have with us today, Professor Marco Torsello. Welcome, Professor Torsello.
Thank you very much. Hello.
Professor Torsello is a professor of law, University of Verona, and global professor of law, NYU Law Abroad program in Paris. Apart from teaching, he practices as partner at Arbitration law firm Milan, where he leads the litigation department. Among other publications, Professor Torsello and Professor Franco Ferrari have co-authored a book titled International Sales Law, CISG in a Nutshell. Today, Professor Torsello will discuss with us why the CISG applies in arbitration and how that differs from CISG's application in courts. Next, we also have with us Professor Gary Bell. Good evening, Professor Bell.
Hello.
Professor Bell has been teaching the CISG at the National University of Singapore for 24 years. He also teaches arbitration and Indonesian contract law. He has acted as an arbitrator in disputes where issues arising under CISG were involved. With law degrees in both common law and civil law, he has acted as expert witness on civil law and on arbitration in arbitrations and court cases. Today, he will discuss about Article 8 of the CISG. We also have on the panel Justice Francesco Cortesi. Good morning, Justice Cortesi.
Good morning. Thank you for your invitation.
Justice Cortesi was appointed to the Italian Supreme Court, becoming one of the two youngest justices ever appointed to the Italian Supreme Court in January 2016. As a judge, he has rendered some of the most relevant decisions concerning the CISG. Justice Cortesi will discuss about how arbitral awards have applied to substantive provisions of CISG. Then we have Professor Franco Ferrari. Hi, Professor Ferrari.
Hi, good morning or afternoon, depending on where you are.
Professor Ferrari needs no introduction. He's considered one of the foremost global experts on CISG and is indeed the architect of today's webinar. He's a professor of law and director of the Center of Transnational Litigation, Arbitration, and Commercial Law, New York University School of Law. He's best known for his work on the unification of law, particularly international sales law. He was instrumental to the development of the UNCITRAL Digest of Case Law on CISG. This digest allows easy access to case laws from multiple countries. Apart from academics, he frequently acts as arbitrator and expert in both commercial and investor-state arbitrations. Today, Professor Ferrari will discuss the issue of economic hardship under the CISG, which is topical as the world braces itself from the likely economic hardship caused by COVID-19. Last but not the least, we also have Mr. Alvin Yeo, Senior Counsel. Good evening, Mr. Yeo.
Good evening. Happy to be here.
Mr. Yeo is the chairman and senior partner of Wong Partnership, one of the largest law firms in Singapore. He's the youngest ever to be appointed senior counsel of the Supreme Court of Singapore. Mr. Yeo is also a member of the SIAC Court of Arbitration and regularly acts as an arbitrator as well as counsel in high-value complex disputes. Today, he will deal with CISG issues in setting aside applications before the Singapore court. This webinar is intended to be interactive. We encourage you to send in your queries to the panelists using the Q&A button at the bottom of your screens, and we'll try our best to address them as we go along or towards the end. To kickstart the discussions, I invite Dr. Rosenfeld to talk about the applicable law.
Thank you very much, Piyush, and let me say that it is a great privilege and pleasure to contribute to this webinar. In my presentation, I will not deal with the CISG in detail, but instead share some general thoughts with you on how arbitrators determine the law applicable to the merits. Professor Torcello will then take over and explain to you how you get to apply the CISG by using or not using the framework that I will outline. As you mentioned, my comments are based on a paper that I co-authored with Professor Ferrari, and I will try to give you a snapshot of some of the 4 key points we try to make in this paper. Our first point is that arbitrators have to determine the law applicable to the merits based on autonomous conflicts rules that are contained in the arbitration framework. A conflicts rule is essentially a meta-norm that does not offer an answer to a specific question of substantive law, but that guides the tribunal in determining the law applicable to the merits. You know this from litigation where a state court will apply the law applicable to the merits based on the conflicts rules of the forum. Historically, there was at some point support for the proposition that arbitral tribunals should do the same. So scholars defended the proposition that arbitral tribunals are bound by the same conflicts rules as state courts at the seat of arbitration. This so-called seat theory was famously endorsed in a 1957 resolution of the Institut de Droit International, and it was further endorsed in F.A. Mann's legendary article, Lex Facet Arbitrum. However, the seat theory did not succeed. Instead, special conflicts rules, which are autonomous from those applicable in litigation, have developed. A prominent example is Article 28 of the UNCITRAL Model Law, which has been implemented in various jurisdictions, including Singapore. Likewise, arbitration rules may contain such an autonomous conflicts provision. So if the parties opt for SIAC arbitration, they will thereby select the rule contained in Article 31 of the SIAC rules. And such an autonomous conflicts rule is the starting point for a tribunal's choice of law analysis. Now let us look at how these rules apply in practice. In this respect, one important takeaway, and this is my second point, is that the autonomous conflicts rules respect party autonomy. Depending on the specific wording of the applicable conflicts rules, parties have the option of selecting a given law for their dispute, to select rules of law, or to instruct the tribunal to act as amiable compositor. Let me briefly explain these options. The option of selecting a specific law essentially means that parties can select the law of any legal system. And unlike in many state court proceedings, parties can select a neutral legal system that does not bear any link to the dispute. So the choice of law framework honors party autonomy to an even greater extent than many modern conflicts rules applicable in state court proceedings. The further option of selecting rules of law sounds similar but does not mean the same. The term rules of law is broader than the term law and includes non-state law, such as, for instance, the unidra principles or the lex mercatoria. In practice, we do not see such choices of the lex mercatoria very often, and the same holds true for the final option of instructing a tribunal to decide ex aequo et bono. Despite claims by Aristoteles in his rhetoric that the ability to decide based on equity considerations is what distinguishes arbitrators from judges in state courts, arbitrators very seldom decide based on equity. And the reason for this is simply that parties do not like this. Equity considerations fail to perform the normative control and direction that is necessary in international business transactions. So the key takeaway on my second point is that the autonomous conflicts provisions respect party autonomy. And business actors are well advised to make such a choice of law when they draft an arbitration clause. We come to my third point, which is that absent party agreement, tribunals enjoy discretion in how they determine the law applicable to the merits. As far as the exercise of this discretion is concerned, some conflicts rules expressly require arbitrators to identify an additional conflicts rule outside the arbitration framework, whilst others allow arbitrators to directly select the law applicable to the merits without such a detour. In practice, this distinction between what we call the voie indirecte and the voie directe is less relevant than it appears to be in paper. This is because even under the voie directe, arbitrators will typically have resort to additional conflicts rules in order to justify their decision. To make this clear, when a conflict rule says, "Dear tribunal, you can select the law applicable to the merits as you deem appropriate," the tribunal will make reference to conflicts rules that developed outside the arbitration context so as to discharge its duty to give reasons. One prominent example of such an additional conflicts rule is the closest connection test. This test is part of various conflict of law codifications, both on a national and an international level. It has even been labeled a general principle of private international law. Pursuant to the closest connection test, An arbitral tribunal will have to apply the substantive law that is most closely connected with the dispute. And according to one approach, which is, for instance, reflected in Article 4 of the Rome Convention, the closest connection exists with the jurisdiction in which the party performing the characteristic obligation of the contract is based. So in a sales contract, we would apply the law of the seller because it is the seller that performs the characteristic obligation. And the rationale behind this is that we want to protect the seller by applying its home state law, because the seller faces more risks than the person that is simply paying money. The closest connection test is certainly not the only conflicts rule that a tribunal may apply, and we discuss various other proposals in our paper. But our conclusion is that the closest connection test is a very suitable conflicts rule because it allows for predictable solution and corresponds with the parties' expectations. And this is the key takeaway on the law applicable to the merits absent a choice. My last and final point is that the choice of law framework, as I have just outlined it, is subject to limitations. One potential limitation derives from the wording of various conflicts provisions, including Article 31 of the SIAC rules, which require tribunals to take account of the provisions of the contract and relevant trade usages. We found support for the proposition in our paper that this caveat actually rather concerns the application of the law rather than the choice of law. Put differently, a tribunal is not required to select a law under which the contractual terms are valid or which is more reflective of trade usages. Instead, a tribunal must merely do the obvious, which is to apply the provisions of the contract or trade usages that are valid under the applicable law. A more relevant limitation derives from overriding mandatory norms. In this respect, arbitral tribunals will in practice often be guided by their mandate to render an arbitral award that is neither set aside nor refused recognition and enforcement. And in discharging this obligation, tribunals will apply certain mandatory norms irrespective of the otherwise applicable law. In conclusion, the choice of law analysis in international arbitration differs from the one applicable in state court proceedings. Arbitral tribunals determine the law applicable to the merits on the basis of autonomous conflicts provisions set forth in the applicable arbitration framework. While the wording of these autonomous conflicts rules may vary, it is fair to say that many of them respect party autonomy to an even greater extent than the conflicts rules applicable in state court proceedings. Absent a choice, tribunals enjoy discretion, a discretion which will in most cases still be guided by traditional choice of law considerations, such as the closest connection test, and which finds limits in overriding mandatory norms. And on this note, I conclude and now hand over to Professor Torcello, who will elaborate on how one may get to apply the CISG by using the framework that I just outlined. Thank you very much.
I assume that I can directly take over from this point. So let me begin by expressing my gratitude to SIAC and NYU for inviting me to this very interesting and extremely successful, given the number of participants, webinar. I must also express my gratitude to the previous speaker, to Professor Rosenfeld, who has done a fantastic job in setting the framework, which is extremely helpful to my presentation and to provide the framework within which I can easily include the few remarks that I want to make. Now, given the excellent presentation that we just heard, although 15 minutes may not per se be a very long time, it is probably more than actually necessary to convey the one single takeaway that I would like to offer to the audience of this webinar. I hope, indeed, that by the end of this presentation, audiences will be able to fully understand that the seat of the arbitral tribunal does not correspond to the forum in court litigation for the purpose of the applicability and for the applications of the CISG, so that arbitrators called upon to adjudicate international sales dispute, or counsel presenting their case, may avail themselves of a replenished legal toolkit in the context of international arbitration dealing with CISG cases. Let me start with a typical CISG scenario and with a case for you to consider. Let us consider the case of international sale between an Italian seller and a buyer with a place of business in Singapore. Before the court of a contracting state, there would be no question as to the applicability of the CISG under Article 11A of the Convention. And if the buyer were to claim price reduction, there would be no major issue, no question that the dispute would be based on Article 50 CISG, which deals with price reduction. If the case is brought to arbitration, now the question is, can the seller argue that the CISG does not apply in that Article 11A scenario, the typical scenario where the CISG would apply? The review of arbitral tribunals case law would seem to support a negative answer. Arbitral tribunals in most cases apply the CISG in cases like the one I just mentioned. However, I would argue that even in the case like the one I just described, the arbitral tribunal may not be bound to apply the CISG if, for instance, the arbitral tribunal were to conclude that the law applicable were the law of the place of delivery, and the place of delivery were the country of a known contracting state. Let me clarify further this somewhat provocative opening statement by referring more closely to the text of the CISG in light of what we already heard from Professor Rosenfeld. My central point today is that the contrary to the seat theory that was already mentioned, domestic courts are firmly anchored to the territory and to the legal mechanisms of the forum state, whereas arbitral tribunals are somehow disanchored from the seat and operate as floating courts in the extraterritorial open waters of transnational commercial law. Of course, sooner or later, also the arbitral tribunals will need to dock back in the territory of a national state, but that is somehow a different story and later story and issue in the story. But throughout the phase of the adjudication of the case, the arbitral tribunal is not linked to the seat in the same way in which the court is linked to the forum. As a result of this, the applicability of the CISG before arbitral tribunals may be based on grounds which are significantly different from what happens before a domestic court. In most cases, the CISG will apply in arbitration as a result of the choice of law made by the parties. And in that case, the CISG will apply by virtue of the parties' freedom of contract and by virtue of the binding force of the parties' choice. One may distinguish different cases: the case where parties choose the law of a non-contracting state, in which case the CISG would not apply; the situation where parties choose the law of a contracting state, which would include the CISG and make the CISG applicable as a result of the expression of the parties' choice. One could also add situations such as the choice of the CISG per se as rules of law, to use the language that the relevance of which has already been pointed out by Professor Rosenfeld, or choices such as the lex mercatoria or the like, which may be deemed to include the CISG. It is more interesting, however, for the purpose of my overall presentation, to focus on the situation where the arbitral tribunal is called upon to decide in a situation where the parties have not chosen the law applicable to the merits of the dispute. And in this case, the question or the guiding principle, which stems from the distinction between the seat in arbitration and the forum in court litigation, leads us to the conclusion that the arbitral tribunal's determination of the applicability of the CISG must be carried out on the basis of the arbitration autonomous conflict rules. And that is different and may overlook to some extent the usual provision that determines the applicability of the CISG in state court as part of the law of the forum. It may be useful to post briefly Article 1, which is in slide number 2 to that in that respect, which gives us reminds us in Article 1.1, letter A and letter B, the grounds for applicability of the CISG before national courts. But that is because the CISG is already present as part of the law of the forum in that court, a situation which is not reproduced in the same way before arbitral tribunals. Arbitral tribunals, or as we were reminded by Professor Rosenfeld, can apply the voie indirecte, as exemplified in Article 28 of the UNCITRAL model law, and refer to the conflict of laws rules, which the arbitral tribunal considers applicable, or can apply the voie indirecte in its two different formats, referring to the law which the arbitral tribunal determines to be appropriate, or the law or rules of law, as in Article 31 of the SIAC rules, which are relevant which may be relevant if chosen by the parties. Now, there are two relevant consequences in terms of applicability of the CISG before arbitral tribunal. On the one hand, Article 1 CISG may be deemed to be addressed to national courts and not to arbitral tribunal. It can be overlooked by arbitral tribunal. They're not bound by Article 1, although some scholars deem Article 1 to contain conflict rules that may be regarded as binding by the arbitral tribunal. The reply to that position would be that first, we need to get to the CISG. And we cannot get, it would be a vicious circle to argue that we get to the CISG through a provision that is contained in the CISG. So it is necessary to start the analysis from the autonomous conflict of law rules that are the arbitration conflict of law. On the other hand, arbitrary tribunals may find the CISG to be the appropriate law and therefore the applicable law, even if the requirements of Article 1 are not met. So even if the same case before a national court would most likely not lead to the application of the CISG, or would certainly not lead to the application of CISG as part of the law of the forum, may lead to the application of the CISG as part of the foreign law applicable, but that would be a different type of approach. What does this mean in practice? And I am quickly coming to an end. Let me apply the approach that I just mentioned to 3 hypotheticals where the CISG expressly or impliedly refers to a court or the forum. 2 notions that I'm arguing are alien per se to the situation presented to an arbitral tribunal. The first situation is particularly relevant in this context because it refers to the Article 95 reservation, wherein the list of reserving states includes Singapore and the United States, among others. The reservation binds only courts in the reserving state. If that statement, which would require a long discussion that we don't have time now to carry on, if that statement is correct, and I believe it is correct, the arbitral tribunal, even if the seat is located in the reserving state, is not bound by the reservation, because that reservation is merely addressed by the reservatory state through the courts of that reserving state. So to give just one example, a Singapore court would not apply the CISG in a sale from a seller based in Singapore and a buyer based in the UK, whereas an arbitral tribunal, even if the seat is based in Singapore, is not bound by the reservation and may apply the CISG. The second hypothetical, Article 96 reservation in combination with Article 12. And in that case, the language, which is reported in slide number 4, leads to relevance possibly be given to the reservation, to the requirements as to form, where any party has its place of business in that state. There are different ways to read this provision, but I would suggest that this provision may be read as suggesting that the requirements as to form in reservatory states are to be regarded as overriding, public policy overriding mandatory provision, which brings us back to what Professor Rosenfeld was saying about the possible duty of the arbitral tribunal to take into account the overriding mandatory rules in addition or irrespective of the law otherwise applicable to the merits. The third and last hypothetical refers to Article 28, specific performance and the availability of specific performance. Some commentators have argued with respect to Article 28 that the reference to court in that provision should include arbitral tribunals. I would actually not agree with that position. And I think that there are 2 separate questions that should be posed. The first one is the arbitral tribunal jurisdiction to make a specific performance order. And that is to be based on the law applicable, and the rules applicable in arbitration. And in most cases, there is a positive answer, even expressly given in jurisdictions such as France or the UK, or impliedly drawn, and this is my understanding about the situation in Singapore from the reference to the type of decision that the Supreme Court could render. The second question is whether a domestic court would uphold or enforce an award ordering specific performance. But that is a separate question, and a question that again may relate to the relevance to be given by the arbitral tribunal to the capability of the award to circulate and be recognized and enforced in different jurisdictions. This may explain why, in fact, specific judgments for specific awards for specific performance, ordering specific performance are rare. But this, as a final takeaway, may also induce at the stage of drafting the arbitration agreement, if parties are in fact interested in possibly having the opportunity of an order for specific performance, to couple that with something like an estranged or a judicial penalty, something that could convert the order for specific performance in monetary relief in the event of non-compliance with the order for specific performance. Thank you very much.
Thank you, Professor Torcello. I'm sorry, I lost my internet connection for a bit, so sorry for the hiccup. But before that, thank you, Dr. Rosenfeld, as well. Very interesting how the conflict rules apply in a court of law and in international arbitrations. Now that we have crossed the threshold issues and the applicability of CISG can be applied by arbitral tribunals. Next, we have Professor Bell, who will discuss about interpretation of statements by parties under CISG, which is Article 8 of the CISG. Professor Bell, please.
Wow, I was on mute. Thank you very much. I'm very pleased to be with you and in such good company. I'm very pleased to talk to you about Article 8, which is about the interpretation of contract and what should be looked at when you try to interpret a contract under the CISG. Now, most of you would know that when it comes to interpretation of contract, the civil law and the common law can be quite different in approach. But let me, for those who might not be familiar, just briefly explain what Article 8 is trying to do. The first thing to know is that the civil law takes, the common law takes a very objective approach. And that is well known by most people. I would say, for example, that the contract is what a reasonable person would think the words of the contract mean. So when you come to interpretation, you just look at the contract. And this is supported by the parole evidence rule, which prohibits looking at the negotiations, for example, and subsequent conduct. So the common law approach is rather objective. The civil law approach takes a more subjective approach. It's not a pure subjective approach. Most of the time, we just look at a contract and it's quite objective. But nonetheless, if you look, for example, at the French code, Article 1188 of the new French code, it says a contract is to be interpreted according to the common intention of the parties, rather than stopping at the literal meanings of its terms. So therefore, we don't look only at the contract. The goal is not what the contract says, but what the parties intended. Now, of course, most of the time, what they've intended, we'll presume, is what the contract said, but there's a more subjective concern about the intent of the parties, which the common law does not share. The other thing we don't have, and it's a consequence of what I just said, we don't have a parole evidence rule, at least in commercial setting. In some French-inspired civil law system in civil matters, there's something equivalent to best evidence rule, but it doesn't apply to commercial settings. So there is no rule of parole evidence rule. Now, Article 8 tries to find a compromise between the two. Let me show you Article 8. Here's what it says. It says that for the purpose of this convention, statements made by and other conduct of a party are to be interpreted according to his intent, where the other party knew or could not have been unaware what that intent was. Now, first thing to say is talks about conduct and statements. But in fact, Article 8 has been seen, and rightly so, as an article on interpretation of contract, because a contract is a statement of offer and a statement of acceptance. So once you try to interpret a contract, the contract itself is a statement. So therefore, the first paragraph, what does it say? You interpret it according to the intent of the party if the other party knew or could not have been unaware of that intent, right? This is a civil law approach, and that's the starting point. You are supposed to look at the intent, search for the intent if the other party knew that intent or could not have been unaware of it. Now, if one of these two conditions is not met, we go to the second paragraph, which is common law inspired. It says, if the preceding paragraph is not applicable, statement made by or conduct of a party are to be interpreted according to the understanding that a reasonable person of the same kind as the other party would have had in the same circumstances. This is again, clearly a common law inspired. What is very different though, is the third paragraph, and most of my talk will be on that paragraph. In determining the intent of a party or the understanding a reasonable person would have had, due consideration is to be given to all relevant circumstances of the case, including the negotiations, any practices which a party have established between themselves, usages, and any subsequent conduct of the parties. This is a clear rejection of the parole evidence rule. Now, this is important to know. Now, if you've noticed, the third paragraph applies not only to the first paragraph, the civil law approach, but it applies also to the second paragraph, which is the common law objective approach. So before you say, okay, let's ask a reasonable person, you have to tell the reasonable person to also look at the negotiations and the subsequent conduct of the parties. So it's quite different from the pure common law approach. Now, the difficulty, there's no difficulty when you go to national court in this way. I mean, maybe the national court will not apply it properly, but one of the things that is clear is that the CISG will prevail over national law. Whether this provision is substantive law or law of evidence doesn't matter. The country that has signed the convention will have to, whatever, if they have parole evidence rule, they will have to abandon it. If they're a common law country, they will have to start with a civil law approach. If they're a civil law country and you cannot make sure that the other side knew the intent, they will have to apply the common law approach. Okay, that's fine. When we go to arbitration, it's a little bit different. And let me show you why. I give you here the answer trial model law, Article 19, paragraph 2. If the parties did not agree, the tribunal may conduct the arbitration in such a manner as it considers appropriate. The power conferred upon the arbitral tribunal includes the power to determine the admissibility, relevance, materiality, weight of evidence. Therefore, no rules of evidence. This even becomes clearer when you look at the rules of institutional rules. Of course, this is sponsored by the SIAC, so I show you the SIAC rules. But frankly, most rules are the same. If you look at 19.2, conveniently the same number as the model law, 19.2, the tribunal is not required to apply the rules of evidence of any applicable law in making such a determination. So the tribunal is not bound by the rules of evidence of any national law, which is quite clear. In fact, in Singapore, the Evidence Act even says that it doesn't apply to arbitral proceedings. So the issue becomes, is Article 8 a rule of contract law, or is it a rule of evidence? And I'm going to focus, I think first and second paragraph are clearly rules of contract law. In common law, we don't say that the rules that you interpret the contract in an objective way is a rule of evidence. It's not, it's rule of contract law. So paragraph 1 and 2 are rules of contract law and substantive law. But there might be a debate about paragraph 3. Paragraph 3 is a rejection of the parole evidence rule. And whether the parole evidence rule is really in rule of evidence is an issue, notwithstanding the name of it. The joke, of course, is that the parole evidence is none of these three things. It's not a parole rule because it applies to writing. It's not an evidence rule because it's actually a substantive law. And it's not a rule at all because there's 1,000 exceptions to the parole evidence rule. So of course, the issue now is whether it is a rule of evidence or it is not a rule of evidence. And in the United States, under the CISG decision, an early decision called MCC Marble Ceramic, it was held that the parole evidence rule was a rule of evidence, a rule of substance, and therefore the CISG was also about substance, and the American rules of parole evidence rule was not applicable because A3 clearly rejects it. Okay. The English would agree, most English will agree with that. English court considers the parole evidence rule as part of contract law. In civil law, we don't really have it, as I mentioned, but once we have something similar in civil matters, doesn't affect commercial matters. In France-inspired jurisdiction have something called best evidence rule. But that rule is part of the civil code, not part of procedure. It's part of substance. Okay. So if it is an issue of substance, paragraph A3, if it is substantial, then it applies because it's usually by choice of the parties. If, as Marco Torsello has explained, it could be another way. The tribunal could have left with no party choice and therefore could decide the CISG applies. But if the parties have chosen the CISG through a national law, then it's substantive law and it applies, and A3, it being substantive law, also applies, and the tribunal has no choice if it is a choice of the parties. However, you have Singapore. And in Singapore, the case of Sembcorp Marine, which is quite well known in Singapore, in that case, the Chief Justice said that the parole evidence rule is a rule of evidence, not a rule of contract law. Now, understandably, you have to kind of say so because it's part of the Evidence Act. And we don't have in Singapore the Indian Contract Act, but we do have the same kind of, originally the same Evidence Act. So it's hard to say it's not a matter of evidence when it's not part of contract law, but part of Evidence Act. That being said, the consequence of it being part of the Evidence Act, it doesn't apply in arbitration. The parole evidence rule doesn't apply in arbitration because of the provisions I showed you before, but also in Singapore because the Evidence Act says it doesn't apply to arbitration. Okay, so what happens then? If that is the case, that the parole evidence rule is not an issue of substantive law, the Article A3, which is a contradiction, the opposite of the parole evidence rule, maybe is also not a substantive law matter. Maybe it is a procedural matter. If that is the case, we might have a problem because the tribunal will not be bound by A3, right? Because it's evidence rules not binding the tribunal. In which case, the tribunal might decide that, sorry, something is ringing and I don't know what it is. I'm gonna just stop it. And the tribunal might basically decide to apply or not apply the parole evidence rule, to apply or not apply A3, because it's not bound in any kind of way. So if they decide to apply the parole evidence rule and decide it has jurisdiction applying the parole evidence rule, then the case is brought to the Singapore court. And the Singapore court, it will be bound by the Evidence Act, right? And will have to apply the parole evidence rule. So you have a tribunal that was free to apply the parole evidence rule, and it decided with the evidence very reduced, and it goes to court in Singapore. And what happens there? Well, you have a situation where the court is bound by A3 because it supersedes the Singapore law, including the Evidence Act. This is not ideal. And there's not many more problems that I could mention. The Singapore position on the parole evidence rule is extremely complex and frankly, a little bit messy in my opinion. And when it comes, you added the difficulty of arbitration plus the CISG, you get in quite a bit of uncertainty there. Now, let me add one point. It's the issue of the merger clause. what if the parties decide that they will put in their contract, and this is usually what common law lawyers do, a clause that says this contract is the whole contract, no other representation, nothing that was said before counts, nothing that will ever be said after counts. This is the whole contract, and the integrity of the contract is here. Such a clause is basically a contractual parole evidence rule clause, if you want to call it this way, right? Such a clause, is it valid given A3? If A3 applies, does this clause prevail over A3? The answer is yes. There's an opinion by the Advisory Council of CISG, opinion number 3. I agree with that opinion. Parties are free to exclude the CISG. So that's Article 6 of the CISG. And therefore, if they make a clause that says they will not look at anything in terms of negotiation and subsequent conduct, they're making an exception to Article A3, which they're allowed to do. And that's not a problem. One last thing, since I see I have about 2 minutes left. One of the issue, of course, is whether the CISG rule A3 will apply to deciding whether the arbitration clause is valid. In Singapore, we have decided in the case of BCY versus BCZ that the norm, I mean, there are many exceptions, but the norm is that the governing law of the main contract will be the governing law of the arbitration clause. If that is the case, the CISG A3 might apply to determine the validity of the arbitration clause. A bit of a problem is that Article 4 of the CISG says it only applies to the formation of the contract of sale. But by the logic of the BCY case, this is okay because the contract of sale includes the arbitration clause. Anyway, I just wanted to point out that this is sometimes a little bit more complicated when you go to arbitration with the CISG. I am a big fan of the CISG, so it's not to discourage people from using it. But especially in Singapore with a little bit of a messy situation in terms of parole evidence rule, that might cause problems sometimes, although frankly, most lawyers won't even plead what I'm talking about. So thank you very much for your attention.
Thank you, Professor Bell. That was very interesting actually to know how different courts will apply this issue under Article 8. In fact, I note that Article 8 was also an issue in BVU versus BVX, which Mr. Yeo will be dealing later, during his presentation. So now we have next Justice Cortesi, who will discuss about how arbitral awards have applied the substantive provisions of CISG.
Thank you, Piyush. Hi, everyone. I'd like to extend my sincere thanks to SIAC and NYU Law School for this invitation. And probably it would be not possible to explain in 15 minutes how arbitral tribunals dealt with CISG substantial provisions. So my aim, my target is just to give you an overview on the subject at stake and just a short forward before entering into the merit of my specific homework. I think that CISG and international arbitration both aim at the promotion, unification, and facilitation of international trade. This is somehow certified by Article 7 of the Vienna Convention, pursuant of which there is a need to promote its international character and its uniformity. And although this could appear rather detrimental for the category I'm representing, I think maybe international arbitrators are better equipped to deliver decisions that reflect this autonomous meaning of the CISG than court judges. This is not my personal belief, not only my personal belief, but I've got the proofs of that through some cases I will show you. But I think in general, it's for three specific reasons. The first is that arbitral tribunals are usually composed by members directly chosen by the parties. And maybe the parties provide for having them more expert in international state law than more expert than the court judges are. Second reason, in fact, arbitration tribunals are usually composed by members from different jurisdictions, so they are particularly able to achieve a truly uniform international interpretation and application of the convention. And the third, and is consequently, international arbitrators usually don't feel any link with their domestic jurisdiction, their domestic law system, and instead this often characterizes the experience of court judges. So I've chosen through cases 4 specific issues. I will briefly trespass in a sort of rhapsodic way because of time we have. And these issues are: the first, the choice of the applicable law. Apart from the consideration I heard from the excellent presentation of Dr. Rosenfeld and Professor Torsello, I'd like you just to focus on the method arbitration awards had adopted in the choice of the application of the convention, so to determine whether or not the CISG applies. The second is the interest issue. The third is penalties. And the fourth is some topics around the payment. So I quickly come to the first issue, and the application of CISG, where there is no provision for the choice of the law by the parties. So what happens when the parties fail to set forth the applicable substantive law? Of course, I pointed out some arbitral awards that didn't persuade me, but I want to underscore two awards that I found out very interesting, one rendered from a Russian arbitral tribunal and the other from a Serbian one, both in 2006. Because moving from the fact, in these words, moving from the fact the contract was presenting an international character and it was at a glance subject to the application of a uniform convention, the tribunal came to a 3 steps reasoning. The first was that the tribunal pointed out the respective states where the places of business of the parties were located were contracting states, so Vienna Convention was applicable pursuant to Article 1(1)(a). Second, the tribunal pointed out the fact the parties did not exclude the application of the convention, and this is relevant because the convention, as you easily know, provides for the possibility for the parties to exclude its application. So to point out the fact they didn't exclude is one of the requisites to state for the application. The third is, at the same time, by virtue of Article 7(2) of the Vienna Convention, issues which are not directly settled by the convention and can't be settled based on its general principles shall be governed to the provisions of a national law determined by the norms of private international law. This method, I find that is very persuasive one. Also, I'd have to point out some arbitral awards that gave relevance to the parties' implicit agreement by the respective assertions in the arbitral judgment itself. For instance, 2 China's arbitral awards rendered in the late 90s, yes, I'm not failing, they said that during the arbitration, both the seller and the buyer applied the CISG to support their defenses. And this deemed the arbitral court to state for the application of the convention. At the end of this first issue, provision for a state law, I point out we have a lot of decisions that, a lot of awards that stated that the mere choice of a state law is not sufficient for considering the existence of an opting out by the parties. Somehow, and I don't share this opinion, sometimes it depended from the fact that it was a consequence of the application of private international law. I thought it better, a decision rendered as well by a Russian arbitral award in 2005, the fact the parties have chosen the Russian state law was considered the possibility to the application of the convention because the convention was considered a constituent part of Russia's legal system. Coming to the second issue, the interest issue, we have a certain point, you know, the interest represent an internal gap in the CISG. And through the habitual awards, I pointed out we have three different positions. One is that this gap ought to be filled by reference to the general principle on which the CISG is based. The second is the issue is more appropriately considered as being outside the scope of CISG. And the third is CISG is not to be mentioned at all on the subject of interests. I think that even if the rate of interest is not specifically considered by the convention, we can fill the gap inside CISG. There is an award, the medicaments case rendered by the Serbian Arbitral Court in 2009 that states that since the matter of interest rate is governed but not settled by CISG, there is no need to examine the seller's request in the light of any national law, but rather examine whether it's within the checks provided in Article 7 of CISG. So the proposed rate has to be determined in accordance with the principle underlying the CISG. For instance, the most important one, the principle of full compensation. Coming to the third issue, the penalties. Of course, you know that we have no CISG provision addressing this specific issue. Anyway, penalties come within the coverage of CISG. They come within the coverage of CISG not for their validity, pursuant to Article 4, but for their scope and extent. You know that Article 74, and it was confirmed by many habitual awards, pursuant to Article 74, damages in a sum equal to the loss suffered as a consequence of the breach of contract, and this sum may not exceed the foreseeable damage. Coming from this point, we have some habitual awards that state that CISG does not provide an answer to the penalty issue and does not expressly settle the issue, but its general principles are relevant and useful. We have some awards pursuant to these specific questions by which the CISG provides for some general principle on which it's based and which are applicable by virtue of Article 7.2, like the principle of compatibility and the principle of admissible remedies, the principle, sorry, of compatibility of admissible remedies to which parties resort in individual situation. And we have a lot of provisions inside CISG that establish this specific principle. For instance, article from 46 to 50, from 62 to 64, from 82 to 83. So in this case, the arbitral tribunal holds that the claim of the buyer for recovery of the sanctions for delay in delivery is not compatible with buyer's claim for refund of the price of the goods, which follows from the fact of avoidance on the contract in respect to the first installment of the goods established by the tribunal. So based on the above, the arbitral court rejected the buyer's claim for recovery of contract sanctions for delay in delivery. On the other hand, for the same reasons, due to some other arbitral awards, CISG does not allow the remedy of penalty within its extent. For instance, it was stated that the penalty may be recovered only in relation to the delayed sums and not based on the total cost of the delivered goods, as was contended by the settler. The fourth and last issue is something around payment. I pointed out two specific questions related to which we have some different decisions rendered by arbitral tribunals. One is the right of the party to suspend its specific or the payment or the installment of the goods in case of avoidance of the contract by the other, by the counterpart. There are no provisions inside CISG related to the right of the party to suspend. And in this case, a decision rendered by a Belarus Court of Arbitration in 2016 stated that although the plaintiff had made the prepayment in full as per contract, and the defendant delivered only a part of the goods, the plaintiff has not the right to suspend this performance of its obligation under the contract. It was on the basis of Articles 71(1) and 3 CISG. Because under Article 71 of the Convention, the party indeed suspend the performance of their obligations, quote, if after the conclusion of the contract, it becomes apparent that the other party will not perform a substantial part of its obligation as a result of a serious deficiency in its ability to perform or in its creditworthiness, or in its conduct in preparing to perform or in performing the contract. So the arbitration tribunal looked for these requirements inside the specific case, and since they didn't find out the aforementioned requirements, they don't have been met, the right to suspend was not authorized. In the same way, a decision rendered by the Chamber of National International Arbitration of Milan in 2001 stated that the buyer's failure to complete the payments of the goods already delivered was without well-founded reason. Consequently, the seller was entitled to recover the corresponding amount. Anyway, the buyer could not refuse to make the payment, assuming a fundamental breach of the seller's side. In the arbitral tribunal's opinion, the principle in ad implentem non est ad implendum doesn't apply to the case at hand by virtue of Article 71 CISG. Last, the round payment, so I'm moving quickly to the end, the specific issue related to the currency. We have some arbitral awards that gave relevance to the general principle applicable to this issue by Article 57(1)(a) of CISG. So the seller's place of business contains an implicit reference to the currency, which has to be determined in accordance to this place. So, of course, excuse me for the rapidity which I shown these cases, but anyway, just some final considerations and final remarks after examining this case and how the way with the arbitral awards dealt with the substantial provision of CISG. For first, I think that the diffusion of arbitral awards by publishing this decision will foster a truly international and uniform interpretation of the Convention. Second, I think that arbitration plays a relevant part in the creation of autonomous sale of goods law. We have more than a 30% decision rendered over CISG cases by arbitral awards. Third and last, arbitrators could and should feel an obligation to help to shape international sales law. Thank you for your attention.
Thank you, Justice Cortesi. You raised some very valid points, and the examples that you gave to explain those points were very helpful. Towards the end, you mentioned about 30% of the CISG jurisprudence, which have resulted from arbitral awards. However, unlike judgments of the courts, awards are not readily available due to confidentiality requirements. Do you think this hampers the development of law under CISG?
Sorry, do you want to know where did I pointed out this stat, 30% arbitral awards and 70% court decisions?
No, I mean, Of course, a large number of them, CISG is applicable both in arbitrations as well as before courts. But due to confidentiality requirements, the tribunal awards are not as readily available, unlike court judgments. So do you think this hampers the development of law under CISG?
Examples?
Does it affect in a negative way from developing the law under CISG?
No, I mean, if I'm not misunderstanding what you mean, because I can't hear you very well. I mean, I have a delay of your voice, and I'm not sure I've understood. But in my opinion, I mean, the fact is not bad. I put reference just to the published decision, and in my experience, for 10 decisions I read, 3 or 4 was rendered by arbitral tribunals. This is a mere statistic. I don't know if you want to obtain, if you want to get a consideration about the merits of the decision. So if you want to, do I need to clarify that arbitral awards are better in point with specific questions than co-decisions?
No, I mean, I just wanted your comment on the fact that since awards are not readily available, whereas court decisions are, and a lot of our CISG disputes are resolved through arbitration, the fact that awards are confidential, do you think that hampers the development of the autonomous body of law under CISG? I wanted your comment on that.
Yes. But I was sure I said it before. It was the first point of my final remarks. We need somehow to have a diffusion of arbitral awards, of course, by publishing it. I know sometimes arbitral awards is confidential, especially in the US, somewhere in American countries, also in the Middle East, or maybe also sometimes in China. But apart from this case of confidential awards, the publication of some arbitral awards will foster the possibility of a uniform interpretation. I find out as a very useful the possibility of read some awards in the databases. Even so, the most part of these awards are a bit old one, because they come from the early 80s, the early 90s, or the 2001, 2002. We have not a lot of recent cases. But in my opinion, somehow we have to promote the publication of the most part of arbitral awards we can.
Okay, thank you. Thank you so much. Professor Ferrari, may I ask you to probably add to Justice Cortesi's comments, because you've been instrumental in making sure that there is a database of case law on CISG.
So yes, I would agree with Justice Cortesi. Let us point out 2 things. A, the database Justice Cortesi refers to shows clearly that in some countries, arbitral awards can be made public, maybe by editing the names. We have more than 450 Chinese arbitral awards on the CISG website, and there are many more from Russia and so forth. That's about the possibility today to find these arbitral awards which have been referred to. The other issue is the one you mentioned. Even if one were not to know about these arbitral awards, I don't think this would be a problem. I mean, as mentioned by Justice Cortesi, they help create case law that is probably drafted better if we talk about arbitral awards than court decisions, as Justice Cortesi himself mentioned, because of the expertise of the arbitral panel vis-a-vis the expertise of judges that have to deal with many other things, not just CISG or commercial or related issues. Still, I think case law, the case law we find today rendered by state courts is the one that will create the CISG case law. You will see that in many arbitral proceedings, reference is indeed made to case law rendered by state courts and not only by arbitral tribunals.
Thank you. In fact, now I will invite you for the next presentation, which is on economic hardship under the CISG. Professor Ferrari.
So, thanks a lot. And first of all, you all know why we do this webinar rather than meeting as we had planned on the 14th of February because of the coronavirus and the consequences thereof. This, of course, fits into what I want to say. I say that because at this point, apparently, some colleagues have questioned whether the coronavirus could be a force majeure cause for exemption. I have to say, there's no question about that. Some colleagues suggest that you, in order to be able to rely on the coronavirus and its consequences, to avoid to have to fulfill or perform your contract, the force majeure clause would have to indicate that it is triggered also by a pandemic. Now, let me be very, very frank. That is nonsense. It should be very clear. Any force majeure clause that we find today lists, not in an exhaustive manner, the reasons why the force majeure clause is triggered, from act of God to war, or actually an act by governments. Of course, even if reference in the force majeure clause is not made to pandemic, you have to be able to look into the force majeure clause and see whether this pandemic and the consequences thereof, such as a lockdown, amount to force majeure as defined in the clause itself. Saying a priori that one has to refer to pandemic in a force majeure clause for the consequences of the coronavirus to be relevant at all in contract law is not really, how to say it nicely, a nice or good thing. I find it nonsensical. Now let me talk about something that we all will face as arbitrator and lawyer today, meaning economic hardship. Now, we all know that the CISG's liability system is a no-fault or strict liability system. This does not mean that under the CISG, a defaulting party has, however, necessarily to always pay damages when breaching the contract. In other words, even under the CISG, there are grounds for exemption. And it is in this respect that Article 79, which you will see on the screen, is relevant. In effect, as stated by one commentator, and I'm quoting, it exempts a breaching party from liability for damages when unanticipated difficulties prevent performance as promised. It is indeed an exception to the general principle that a breaching party must compensate a party for losses caused by the breach without regard to fault, as I mentioned earlier. Now, the issue to be dealt with today is whether economic hardship, which I want to define here as the occurrence of events fundamentally altering the equilibrium of the contract, either because the cost of a party's performance has increased, or because the value of the performance a party receives has diminished, is among the grounds of exemption covered by the provision which you see, meaning Article 79 of the CISG. Or to put it differently, whether there is space under the CISG for a rebus sic stantibus excuse, given that one of the general principles underlying the CISG is that impossibilia nulla est obligatio, despite the general obligations that pacta sunt servanda. Now, the starting point of any inquiry into the meaning and scope of any of the CISG provisions, including Article 79, is, as we all know, constituted by the text of the provision itself. In other words, like any other treaty, the CISG is generally to be interpreted according to the four corners of the document. This textual approach is fundamental to the interpretation of the CISG and any of its provisions, including the one to be dealt with here, Article 79. What I've just said does not mean, however, that other methods of interpretation have to be disregarded or cannot influence interpretive results. In effect, as also stated by, for instance, the German Supreme Court, even an interpretation that contradicts the wording of the CSG can at times be justified, as in those instances where very important reasons of justice for doing so exist, or when it is clear that in light of other types of interpretation, such as a historical interpretation, a systemic interpretation, a teleological interpretation, that the result reached by means of the literal interpretation is untenable. Now, in light of this, the inquiry into the scope of Article 79 and therefore whether hardship does or not fall under the scope of application of the provision, Article 79, has to start with a look at the text of the provision. So I don't refer to the text of the provision, you see it, but I'm basically focusing on Article 71.1. Now, Article 79.1, if you read it, is not dispositive of the issue meaning of the question I'm addressing today. If you read Article 79, and I see that you have it on the screen again, that provision or the literal interpretation does not solve the issue. Resort has therefore to be had to other types of interpretation, in particular the historical one, which, however, interestingly enough, both the scholars denying that Article 79 covers economic hardship and so suggesting on the contrary that it does, have resorted to in order to corroborate their respective arguments. Now, from this already, you should see that the historical interpretation also is not conclusive. As regards the historical interpretation, however, it requires that the legislative history of the provision be interpreted or be taken into account to interpret the convention. Unfortunately, however, the unclear, if not outright confusing legislative history of Article 79 is, as I said, not really helpful. In fact, and resort to Article 79 history is, however, not entirely futile. It reveals, for example, that Article 79 is indeed stricter version of its predecessor, Article 74 of ULIS, which had been criticized for excusing non-performance too readily, such as where performance merely became more difficult. This can be derived from the fact that the expression circumstance in the old provision was replaced by the new expression impediment in 79, with the intent, and this, yes, you get out of the legislative history, of narrowing the exemption under Article 79. But this does not have to be read to mean that economic hardship is excluded from Article 79 scope, as some colleagues wrongly do. Rather, the term impediment in itself is neutral and does not conclusively solve the issue once again. As a consequence, some opine that there is no place in the CSG for any relief on account of economic hardship, while others consider that the wording of 79 is sufficiently flexible to include an extreme situation of unexpected hardship within the meaning of impediment. So you see, as mentioned earlier, as anticipated, the legislative history is not really conclusive. It seems that the view that hardship is not excluded from the scope of application today, but it is somehow governed by the CSG, is the prevailing one. In effect, and here I'm quoting from a decision, while some put forward that the convention excludes the concept of hardship, the majority seems to be in favor of reading it into the CSG. This is also a view shared by CSG Advisory Council, which in its 2007 opinion stated that, and I'm quoting, a change of circumstances that could not reasonably be expected to have been taken into account, rendering performance excessively onerous, hardship, may qualify as an impediment under Article 79.1. Now, the language of Article 79 does not expressly equate the term impediment with an event that makes performance absolutely impossible. Therefore, and this is really the important reason, A party that finds itself in a situation of hardship may invoke hardship as an exemption from liability under Article 79. Let's be very clear. This does not mean that the defaulting party claiming hardship will be easily exempted from liability, as case law clearly shows, but only that one can turn to the CISG, and the CISG only, given that it presents resort to domestic law to the extent that it covers an issue, something Professor Bell addressed when dealing with the relationship between Article 8 CISG and Singapore domestic procedural law, for example. In effect, an exemption is out of reach in most cases of hardship, I have to say. This is due to the hefty additional requirements in order to trigger the exemption itself. But, and this should be very clear, not because the CISG does not allow for it. Even those advocating that the CISG governs hardship, as I do, for example, and I'm sure you have gotten the message, recognize that exemption from liability can only occur when the contractual equilibrium has been fundamentally altered, so that performance would extremely be onerous or excessively onerous. Now, in the last 4 minutes, reference to case law, in my opinion, is relevant. In 2007, when the aforementioned CISG Advisory Council opinion was drafted, the rapporteur was then able to state, and I'm quoting again, to this date, there are no reported decisions whereby a court exempted a party from liability on the ground of economic hardship. However, that of course is a wrong statement, because even by that time in 2007, the French Supreme Court had rendered a decision, at least implicitly acknowledging that hardship is covered by the CISG, and an arbitral tribunal had actually expressly done so already in 1996. Now, it is worth pointing out, however, that in 2009, in a landmark decision, the Belgian Supreme Court in Scafom International BV, a case where the seller gave notice to the buyer that it was forced to recalculate the agreed price because of an unforeseeable increase of 70% in the price of steel, stated that while Article 79 covers force majeure cases exempting from liability, it does not implicitly exclude the relevance of less than force majeure situations such as hardship. I'm quoting from the decision. In effect, changed circumstances that were not reasonably foreseeable at the time of the conclusion of the contract and that are unequivocally of a nature to increase the burden of performance of the contract in a disproportionate manner can, under circumstances, form an impediment in the sense of this provision of the CISG. Now, not only, the court also stated, and I'm quoting again, that the party who invokes changed circumstances has that fundamentally disturbed contractual balance is also entitled to claim renegotiation of the contract. Now, the Belgian Supreme Court based this last statement on the unidroit principles, which the court considered to have resort to in order to fill gaps left by the CISG. Now, that is clearly wrong. There is no way you can equate the unidroit principles as general principle under Article 7 to fill internal gaps. Unfortunately, that's a Supreme Court decision. Unfortunately, this Supreme Court decision was followed in 2015 by yet another Supreme Court decision, this one from France, which also took, in my opinion, the correct position that economic hardship is covered by the CISG, but the wrong position that the consequences, the need to renegotiate the contract, can be derived from the unidroit principles. Now, I only have 1.5 more minutes, so I will be short. Some colleagues believe that you can actually get out of economic hardship, or even if one were correct to state that economic hardship is covered by the CISG, where the contract itself refers to price adaptation in case of price fluctuation, that economic hardship is out because of the requirements which you saw in Article 79, meaning that there has to be a foreseeable event or an unforeseeable event, actually. That too, in my opinion, is wrong. I say that because what if you have a contract that refers to a specific type of price fluctuation and price readaptation? Let's say the contract states if the price change in price amounts to up to 30% of the price agreed upon, then 1, 2, 3 happens. Now, what if the change in price is 89%, 250%? Now, clearly that, in my opinion, because of the provision existing in the contract, has to amount to an unforeseeable event. I say that, but some colleagues, to be fair, wrongly say the opposite. They say, no, every price fluctuation is actually always foreseeable. In my opinion, that cannot be. If at all, you have to link it to the nature of the goods, economic relationships, and so forth. Now, in conclusion, and there's a lot to say, there's a lot, not a lot, but there's some case law that could be helpful, we can discuss it. In conclusion, the CSG does indeed cover economic hardship. You have to meet, if you want to claim exemption in view of this economic hardship situation, you have to actually meet all the requirements set forth in Article 79 of the CISG, because that's a provision you resort to as a general principle. So its requirements have to be met. Ultimately, they will not be met very often because the threshold is high, but it has happened. Thank you very much.
Thank you, Professor Ferrari, for succinctly laying out the position whether economic hardship is in or out of CISG. We have a number of questions coming through, and this is to Professor Ferrari, actually. We have an attendee who is asking, can you state some instances how the equilibrium of the contract is disrupted? Are there any other additional requirements to resort to Article 79 of the CISG?
Now, if you refer to other requirements, meaning other than those contained in Article 79, my answer is no. For a party to be exempt from liability, that party has to prove cumulatively that A, the reason for that party's non-performance lies in an impediment beyond that party's control. For example, the coming into force of an unexpected statute by a government imposing a price hike or a price drop for petrol or gas. 2, that defaulting party could not reasonably be expected to avoid or to surmount the consequences of the unforeseeable event by any alternative means. And of course, that there's a causal link between non-performance and the impediment. Now, as far as unforeseeable event is concerned, some colleagues, in my opinion, wrongly state, oh, the price hike has to be at least 300%. That does not make any sense. You cannot set forth certain numbers, these kind of numbers. You have to look at the case on a case-by-case basis.
Thank you. Yeah, so now we will move to the last presentation of today, and Mr. Yeo will be looking at CISG issues which have arisen in cases before the Singapore courts for setting aside of awards.
Thank you, Piyush. I also wanted to express my thanks to SIAC and NYU for putting this webinar together on what is clearly a very relevant topic in our times. I feel honored to share the virtual rostrum or podium with some of the foremost world experts on CISG. What I'm going to talk about, in a sense, is a little bit different. You've heard very learned insights on how the CISG is applied, for instance, in arbitral disputes. I'm going to be looking at some decisions where parties have applied to the Singapore courts to set aside arbitral awards. And the test in setting aside, just for the benefit of you who are less familiar with the jurisprudence in this area, is something different, because you don't, one of the fundamental principles is you do not review the merits. So you will not have the courts, in a sense, examining how well or how poorly the arbitral tribunals applied the CISG. Rather, the test is something else. And that is often the grounds for setting aside, certainly for Singapore-based applications, are governed by our International Arbitration Act, which gives force to the UNCITRAL model law. And so, again, for the benefit of those of you who are less familiar with the UNCITRAL model law, you will have grounds based on Article 34, 2A2, Roman 2, Roman 3, Roman 4, which deals with, for instance, in that order, not being able to have an opportunity to present your case, having disputes which are beyond the scope of the submission, and not following the arbitral procedure. I appreciate there's a lot of detail, and so I hope you'll forgive me if I have prepared some slides to set out some of the facts of the case, so that in a sense you don't have to sort of like concentrate over hard on remembering all the facts. And I will try, if you like, to try and draw out the main thrust of the reasoning from those cases. So if I could just get some assistance on that, thank you. If I could go over to the next slide, that's what I'm going to be talking about, how the CISG is featured in arbitration-related proceedings in the Singapore courts. And I'm going to pick up on 3 cases where the CISG featured in the arbitral award. The first case I'm going to talk about is from 2012, involving a company called Querela, and another company from Italy, and another company called Celta, an Australian company. They had entered into a distributorship agreement, and there was a clause in that contract which provided that the agreement would be governed by the CISG where not applicable, and where not applicable by Italian law. And there was another clause 26, which essentially provided for any disputes to be resolved by arbitration in Singapore under the ICC rules. There was a dispute on the applicable substantive law. Essentially, Celta considered that Italian law should apply. Querela, who originally had agreed that it would be Italian law, sort of shortly before the hearing changed their position and was seeking to argue that the CISG should be applied. Now, what happened in the arbitration is the tribunal looked at clause 25 and construed it to mean that the parties had intended for the CISG to apply, but to the extent that it is applicable according to the CISG's own rules of applicability. So if you like, they respected the party's choice in the sense that they could see that the starting position, if you like, was the CISG, but depending on whether it would be applicable under the CISG's own internal rules. They then went on to say that based on the CISG's internal criteria, the CISG did not apply because this agreement did not contain a contract of sale. Rather, it was a framework agreement for the distributorship. Accordingly, they went on to apply Italian law under the terms of clause 25. And Querela, who was unhappy with that, applied to set aside the award on 2 grounds. And if you go over to the next slide, one ground was under Article 34, 2A4. And this is the ground in the model law, essentially where a complaint is made that the arbitral tribunal did not follow the arbitral procedure which was in accordance with the parties' agreement. So for instance, you have Article 17 of the ICC rules, which provides that the parties are free to agree upon the rules of a law to be applied by the arbitral tribunal to the merits of the dispute. And the argument there was, well, the parties have agreed upon it. Look at clause 25, which says the CISG is to be applied. And so the High Court looked at the tribunal's reasoning as to why the CISG was not applicable, and essentially held that the tribunal did, in accordance with Article 17 of the ICC rules, respect the parties' agreement because they construed clause 25 and they tried to apply it. The High Court then went on to say, really Querela's complaint was that the tribunal had, if you like, applied clause 25 wrongly. by determining that the CISG did not apply and hence to apply Italian law. And this they considered was not a dispute which engaged Article 34(2)(a)(4) because the parties, which the tribunal had followed the arbitral procedure, but they had construed it in a particular way, and Corrella's complaint really was the way they had construed Clause 25 and the CISG, and that made it an error of law rather than a breach of procedure. And coming back to the fundamental principle that the courts cannot review the merits of an arbitral award, this did not avail Corrella in their grounds for setting aside. Moving over to the next ground, the next slide, Corrella also tried to argue in terms of Article 34(2)(a)(3). And this is where the tribunal decides on matters beyond the scope of the submission to arbitration. And Corrella's argument was that by applying Italian law, when the contract provides for the CISG to apply, the tribunal had gone beyond the scope of submission to arbitration. And here again, the court disagreed because the issue of what was the governing law was a matter which was submitted to the tribunal. They had considered this issue, looked at Clause 25, considered that CISG was to apply, provided it satisfied the CISG's own rules of applicability, and then decided it did not apply according to that criteria, and went on to find that Italian law applied. So essentially, the High Court said that Corrella's complaint was based on a disagreement with the interpretation that the tribunal took regarding the choice of law clause, and not that the choice of law was a matter that was not submitted for arbitration, and hence within, if you like, the scope of the submission to the tribunal. And they went on to say that really Corrella was inviting the court to review the merits and essentially come to a different conclusion from the tribunal, that in applying Clause 25, CISG should apply according to its internal criteria and hence not to apply Italian law. And really going into the merits of the dispute was something that the tribunal, that the High Court could not revisit under the model law. If I could move on to the next slide. The next case I just wanted to, if you like, showcase is another case called Triulzi Cesare. Triulzi, also an Italian company, and I assure you that's purely a coincidence, and the choice of these cases has nothing to do with the constitution of our distinguished panel. So Triulzi and a Chinese company called Xinyi had entered into 3 contracts for the purchase of washing machines. Now, none of these contracts contained a choice of law clause. They all contained a clause for disputes to be resolved by arbitration in Singapore, according to ICC rules. Now, the tribunal had found in the Chinese company's favor and dismissed Triulzi's counterclaim. And Triulzi applied to set aside the award on 3 grounds. Now, I'm going to pass over the first 2 grounds because they had nothing to do with the CISG, related to the admission of evidence. But it was the 3rd ground that they started talking about the CISG. So if you go over to that next slide, the ground under the model law that they founded the complaint was that it was not in accordance with public policy. And essentially, Triulzi said, well, look, there's no choice of law clause, then the Singapore-seated tribunal has to apply the CISG because the CISG is an international treaty which Singapore has signed and ratified. And the High Court said, well, it's not correct to say the tribunal had not applied the CISG because the tribunal had found that Singapore law applied, and Singapore law has actually enacted legislation to give effect to the CISG. So in effect, when you say Singapore law applies, you're also applying the CISG, which has been given the force of law in Singapore. And they also referred to a particular paragraph where the tribunal actually applied the CISG on the burden of proof. But if I can move over to the next slide. What the High Court went on to say was that even if the tribunal had not applied the CISG, it still doesn't come within Article 34(2)(b)(2), because essentially public policy, what constitutes a violation of public policy as a ground for setting aside, is limited to very, very narrow grounds, which essentially require something to shock the conscience, or which outrages public notions of justice and fundamental fairness. And essentially complaining that they had failed to apply the CISG in a particular way, or all the other provisions of the CISG apart from Article 35, simply didn't fall within the parameters of public policy. Because my time is ending, let me move quickly to the last case, which is the case of BYU and BVX. Right. And as Piyush mentioned, this case actually featured Article 8, which you heard Professor Bell speak about. And essentially, and perhaps if I can just summarize what the complaint was. The complaint made in this case, the tribunal had applied Clause 8 in interpreting the various contractual provisions. So they went through that three-step procedure, which Professor Bell talked about. And really the complaint made by the supplier who lost the case was they said they got hold of somebody that was, they wanted to be called as a witness by the other side, but wasn't called. And he was willing to come and give evidence to say that the purchaser who had won the arbitration actually had a different understanding of the contractual provisions. And they considered that was fraud or in breach of public policy, and hence the award should be set aside. And if I can move over to the next slide, that essentially shows you Article 8, which you've seen from Professor Bell's talk, so I'll pass over that. If I can move over to the next slide. They essentially found that I'm sorry, this is still part of the summary, so I think I can skip over this slide, which I to save time. Now, the High Court said there are three requirements you need to show to succeed on setting aside for fraud. And one was deliberate concealment, the other was a causative link between the concealment and the decision, and the third was no good reason for the non-disclosure. Now, 1 and 3 obviously overlap. And the High Court found there wasn't a deliberate concealment because essentially the purchaser actually didn't think that the evidence was relevant. They had at an early stage indicated which witness they were going to call. And in fact, the supplier had applied to the tribunal to direct that the purchaser call 3 more witnesses, including this particular witness that they managed to get hold of after the arbitration. The tribunal heard the arguments and dismissed it. So essentially the point was argued before the tribunal and they ruled in favor of the purchaser. So it could not be said that the purchaser, in not calling this particular witness, had deliberately concealed any matter or had no good reason for not calling that person. On the second ground of the causative link, that means, did this concealment affect the final decision? The High Court considered that E's evidence would not have made an impact. And the reason for that being the issue of the contractual provisions was going to be looked at objectively. You'll remember those 3 limbs to Article 8 that Professor Bell talked about. The first one talks about following a party's subjective intent, provided the other party knew about that intent or could not have been said to be unaware. In this case, there was simply no evidence of what the supplier's subjective intent was and whether the purchaser knew what that intent was. So essentially, you went down to the second limb of Article 8, which means you look at the clauses objectively. And once you look at the clauses objectively, a particular witness's own understanding of the clause simply became irrelevant. And for that reason, the causative link requirement simply wasn't met. And I hope that going through these three cases has shown you how the CISG applies, if you like, in real life, not just in the arbitral award, but also in parties' attempt to set that aside. In fact, picking up on Piyush's question to Justice Cortesi, one way that arbitral awards get aired publicly is when parties apply to set them aside, because in the court judgments which are reported, you sometimes get an insight to how the sort of reasonings and the arguments and the cut and thrust in the arbitration, and in this particular instance, of how the CISG was put to work in those particular matters. So thank you very much for your attention.
Very interesting, and how even at this stage of set aside, we can learn how CISG is applicable. I wanted to note very interestingly, but the first case Mr. Yeo mentioned, Querela, actually had Professor Gary Bell as the arbitrator. Professor Torcello's had filed an expert opinion, and that judgment also referred to Professor Ferrari's article on the issue. So Professor Ferrari, I mean, if you have any comments on the case.
Look, I'm glad that you actually referred to it. The arbitral award was perfect, and you have mentioned it. It was rendered by sole arbitrator, Professor Bell. He and I talked about it afterwards. Everything was really perfect, the way he led up to it. There's one issue mentioned by Mr. Yu, which I disagreed with, so I was actually engaged by the losing Italian party. I do believe that the choice of law, meaning referencing the CISG expressly and, if not applicable, Italian law, to me was an extension of the CISG's applicability. In my opinion, you can do that. Policy-wise, it was a wrong decision to take by the court, I have to say, because it means that you have basically taken away the possibility to extend the CISG's sphere of application. I, of course, do know and submitted it to the courts, and I do know that the CISG does not apply to distribution agreement. I wrote a lot about it. But in my opinion, this was different. This was meant, in my opinion, to suggest that the provisions that the parties wanted to use of the CISGs that could be used in a distribution agreement setting should be used. So, but unfortunately, the court cited a paper where I thought I wrote something a little different. It was about the possibility to annul the award, but it added a not. Professor Ferrari and Linda Silberman stayed, and they added a not. I do not know how. They should have gotten to the other result, but as mentioned earlier, I know that award intimately. It is perfect. I use it as a way to go forward. I just have a different view on this issue. And allow me to say, in Italy, there's another part. In Italy, it worked. It was not enforced.
Yeah. Could I no, it's really interesting to hear all the architects of the award and the experts behind the scenes speak to it. But I'm very glad I referred to that case. I just wanted to say that I don't actually disagree with Professor Ferrari's view on CISG. I guess in this case, what I was going to say is that what the court was trying to do was apply the policy, if you like, of minimal judicial interference in arbitral awards. And I think that was the principle that they were trying to apply first and foremost. And they took the view that because the arbitral tribunal, none other than our distinguished Professor Bell, had actually tried to apply Clause 25. And as I said, there might be individuals, learned individuals who disagree with how Professor Gary Bell applied Clause 25, but he did. He applied Clause 25, and hence, to that extent, was following the parties' agreed arbitral procedure. Now, if you disagreed with how he applied it, they then treated it as a mere error of law, which they couldn't revisit even if they thought it was an error of law. And in fairness to Professor Bell, they did not say it was an error of law. They simply said, well, even if he's wrong, they can't intervene. So it was, if you like, a clash of two policies. One, the promulgation and widespread use of the CISG, and probably from their perspective, they were giving greater weight to the policy of minimal cural intervention in international arbitration.
But the point made in the expert opinion was a little different, apart from what I mentioned earlier. I made the point to say this is different, as you correctly point out, from wrong application of a law. I did not say that. What I said is a little different. I said, here there is a policy. The parties have expressly chosen a law, in this case, set of rules CISG, and disregarding it, even though in favor of the law with the reasoning mentioned by you, disregarding it is a grounds for annulling the award. In fact, the paper cited by the Supreme Court that I co-authored with Professor Silberman was a paper on exactly that, the consequences for an arbitrator disregarding an express choice of law.
I guess it goes back to the principles applicable, at the seat of the arbitration, which is determining whether the award can be set aside, and whereas in an enforcing court, the principles could be slightly different, and of course how the courts will apply those principles. So we'll stay with this, Article 8, and I have a question for Professor Bell. We have an attendee who is asking, is it possible to interpret the arbitration?
Piyush, may I just interrupt you? Sorry, I see that Professor Bell, who has been referred to on various occasions, would like to say something.
Absolutely, absolutely.
There's very little I can say, because it's always difficult to comment on the court decision, because there's part of the, even though the court cited a lot of my award in that case, it didn't cite the whole thing, and I always fearful that I will reveal something I shouldn't be revealing if I comment on such a case. So I won't say very much, but what I will say is that I never said in the award that a party could not choose the CISG directly and not through a national law. So that's not a position. So in a sense, Franco, I agree with you. This is a possibility, and particularly under the SEC rules, which allow for the choice of rules of law. So I don't disagree with that in principle, and that's not something that I said in the award or that a court has said. I just don't think it was the case here.
Sure. Just coming back to the question that I wanted to pose to Professor Bell, we have an attendee who is asking, is it possible to interpret the arbitration agreement based on Article 8, considering that the arbitration agreement is separate from the original sale contract?
Yeah, this is the issue is which law applies to the interpretation of the arbitration clause. This is a debate. Not everyone agrees on that. Some people are of the view that the law of the seat should be the applicable law, the substantive law of the seat. I disagree with that. I think as a normal rule, and this is a rule in Singapore, BCY case, the presumption is that when a clause is part of one contract, the same law applies to the clause as the law applies to the contract. What I said previously today is that when it comes to the CISG, it does specifically say in Article 4 that it only applies to the formation of the contract of sale. I don't think this means it cannot apply to the arbitration clause, because the contract of sale includes an arbitration clause, which is the logic for why the same law would apply to the arbitration clause in terms of substantive law. But many eminent people, including the president of the court, Gary Bourne, disagree and think it would be better if it was the law of the seat, but on that we disagree. But I think one of the things I can say is that when you go to the vis moot, which is of course a moot, every year they don't give you the law of any country, and the poor students have to argue whether the clause is valid or not. And the only law that they have is the CISG. So I've seen the CISG being applied in that way for many years at the Vismut. But I think it's the logical thing if you are of the view that the substantive law of the main contract should apply to the validity of the arbitration clause.
Piyush, may I add one thing?
Sure.
I agree even for another reason. Separable does not mean you cannot apply one and the same law. That should be very clear. Separable just means that the death of one, the main contract, does not necessarily lead to the death of the second arbitration agreement. So that's the only thing what separable means. And I'm one of those who have written a lot on exactly this issue. CISG can apply to, and Article 8 can apply to the interpretation of an arbitration agreement in a CISG related contract. I don't have any doubt. The last court to say that was a court in 2018 in the US, a very good court, the Second Circuit actually said so. In the Transma case, it just makes sense. But separability is a different issue. It does not exclude the application of one and the same law to the two agreements.
Okay, thank you. We have some time left before we end, and we have another question from the attendee. This is to Professor Marco and also Mr. Yeo. The question is, the fact of non-consideration by the arbitral tribunal of the CISG reservation, for example, the reservation of writing form of contracts of related state members, can this lead to the award being set aside?
This is a very good question. My argument with respect to the requirements as to form, which may be imposed by declaring the reservation under Article 96 and Article 12, is that one possible reading of this reservation is that in the reserving state, the requirement as to form is regarded as a public policy matter or an overriding mandatory provision. Now, the typical scenario, however, is that the issue might arise not at the stage of the setting aside, so in the country of the seat, but is more likely to occur at the stage of enforcement as grounds for denial of recognition and enforcement in the reserving state where the award is being brought for recognition and enforcement. But the question, well, the first question is, does Article 96, the combination of Article 96 and Article 12 qualifies as overriding mandatory rules and therefore public policy? And I would say that it is possible to argue in that sense. And of course, then from that premise, the consequent flows that if the reserving state is the state of the seat, it is a possibility to challenge the validity of the award. If the reserving state is the state of recognition and enforcement, it is possible to deny recognition and enforcement on grounds that it does not comply with a public policy provision in the state of enforcement.
I was going to say that it is a very interesting question. I do look forward to it coming up for actual sort of like decision at some point in time. I suppose the only ground or way you would fashion it would probably be on the public policy ground. So yes, I do agree with Professor Torsello that would be the head under which it arises, if at all.
Okay.
There is, if I may follow up very briefly, one very old case that from Argentina, where there is a reference to public policy with respect to Article 96. Although the context was different, it was not referring to an arbitral award, but there is at least one precedent, a pretty old one, where there is a reference to public policy as the ground justifying the reservation under Article 96.
Okay. I actually have a question, and which I'm going to throw it to the panel in general. In my experience, I mean, we spoke earlier about the law applicable to the substance of the dispute. And of course, you can specify it. If it's not specified, then the other provisions will kick in, and the tribunal will come to a conclusion as to what that law is. In my experience, I have seen at a lot of times the law applicable to CISG is actually excluded from by the parties. And I note that in the article that Dr. Rosenfeld and Professor Ferrari have written, they have said that this is not a very good idea. I wanted to get some of your thoughts as to why parties generally do that and why this may not be in their favor.
Oh, I'll answer very quickly. It's nonsense to a priori opt out of the CSG. I always say these things so that you remember them. And when I say it's nonsense, I'm only referring to the fact that you a priori exclude the CSG. That doesn't make any sense. Let me give you a few pieces of information. The CSG contains what is the best rule in the world for creditors of any amount of money. Why? Because Article 78, for example, is the best rule because it starts allowing one party to interest on a sum in arrears as of the moment of non-payment without there being a need to actually give notice, like in some countries you need to do. So there's no better rule than that. So who's normally the creditor? Statistically speaking, of an amount of money, it's the seller who's the creditor of the purchase price. Okay, next. Article 74. Article 74 is the rule that limits damages to foreseeable ones. Okay. It limits damages to foreseeable ones. Who will normally need it? In my opinion, statistically speaking, it is the seller who will need to resort to Article 74. Why? Because statistically speaking, it is a seller who does not have as much control over the goods he or she has imported from another country or the goods he or she is producing himself. Because on the other side, it is just the buyer who just, so to speak, has to pay the price. So you understand that I would never a priori suggest that the seller opts out of the CSG. The seller is better off applying the CSG than some domestic laws I can come up with. We have here Professor Rosenfeld. In Germany, for example, there is no a priori limit to damages. They have to be the immediate and direct consequences, but there's no rule like Article 74. So you understand that the German seller is better off under the CSG if potentially he or she will do something that does not conform to the contract, and more so he or she is also the credit of the purchase price and therefore will also prefer Article 78 over German law.
Piyush,
Sure.
I was just going to add, sorry, Gary. I was just going to add that I do wonder whether for a lot of drafters of contracts, they opt out of it for one of two main grounds. One is ignorance or lack of familiarity. And they're more familiar with their own system of law, so they're less familiar with something like CISG, and so they're just afraid of the unknown. They miss something, so they leave it out. The other scenario is less, if you like, benevolent, which is, I think for many of us, we agree the CISG is actually an attempt to come up with a balanced system of rules to balance the interests of both parties and to prevent one side from taking advantage of an unequal bargain over the other. But sometimes drafters don't want that. And if they have the bargaining power to sort of put in more one-sided provisions, they do so. So I think the CISG has a place in the world, but it is a constant battle of education, I think, to get people to understand the virtues and to stick with it.
Piyush, may I just say one thing?
Sure.
I'm always amazed when the CISG is rejected. It's true, a lot of the time because people don't know it. But it is not a foreign law. It is part of Singapore law. So a Singapore lawyer who gives advice to his client to exclude CISG without having checking what it is inside the CISG is professionally liable, actually. I mean, he is not knowing his own law, is giving advice blindly. And this is really not acceptable. I think Singapore lawyers have a responsibility to decide. I mean, I'm okay if they want to exclude the CISG after thinking about it and what's in the best interest of their client. But they cannot give the advice, as unfortunately a lot of Singapore lawyers are doing and common law lawyers are doing, to exclude the CISG without knowing what's in it.
Sure.
But, Gary, I 100% agree. Let me add one thing. A lot of trade associations suggest, for the reasons mentioned by Mr. Yeo, meaning ignorance, because they think that they want to continue to do business as they did before, to exclude the convention. That's even worse than a lawyer in a given case. Trade associations, unfortunately today, in certain areas, for sure, commodities, for example, consistently suggest to exclude it. That is not appropriate. Not good for them. We have enough work anyway.
Dr. Rosenfeld, any final comments on this?
No, I very much agree that it's often ignorance that leads to the exclusion of the CISG. Often you also have lawyers that are lawyers who are not disputes lawyers that use dispute resolution clauses from other contracts, and they don't really think about whether in a given case the CISG is suitable or not. And that's what I think in most cases actually explains why we have an exclusion of the CISG very often in practice.
Okay. Justice Cortesi, would you like to make any comments on this before we finish? You're muted, I guess. We cannot hear you, Justice Cortesi. Can you unmute yourself, please? Oh, yes.
Yes. No, I don't want to add anything. I mean, I totally share this last suggestion rendered by Dr. Rosenfeld.
Thank you so much. So I guess we have run out of time, and you know, this is a topic which obviously 2 hours also wasn't enough. And I guess as we head towards the weekend, we have enough food for thought, and we are ready to raise a toast. And thank you so much to all our panelists and all our attendees. We had over 1,400 sign-ups for today's event. But before you leave, we request you to fill in the feedback form. And thank you so much. Take care and stay safe.
Thank you, everyone.
Thank you to everybody. Stay safe.
Thank
Bye.
you.
Thank you.
Bye-bye.